Ladies and gentlemen, welcome to today's webinar. Today's seminar topic is your IRA ready for this brave new world? Our presenter today is attorney Thom Shaw. If you'd like a copy of today's presentation, you'll find it in the handout section of the webinar interface. Similarly, if you have a question, you can type it into the questions section of the webinar interface. And now, without further ado, let me turn it over to you, Thom.
Hello, and welcome to our seminar. I thought about wearing a mask today, but then I thought no one would be able to hear what I was saying, so decided against it. But I'm definitely social distancing. My name is Thom Shaw, as the announcer said. I specialize in wills, trusts, and estates. The bulk of my clients are professionals and business people who try to work and set up their businesses and then figure out how to transfer that onto their family in a way that is helpful to the family and avoids taxes where possible. I'm going to do the presentation for about 50 minutes, and then there'll be time for questions at the end. So again, welcome. Basically, we've got the agenda here. I'm going to just introduce why we're having this conversation today. I'm going to cover two acts that have just been passed, one in December and one just in the last month. Then we'll also talk about some other planning options that are related to the fact that we're in this pandemic. The 2020 CARES Act and the 2019 Secure Act have changed the rules for IRA distributions, and they've changed them for you. They've also changed them for your named beneficiaries. So we'll talk today about how to stretch out your beneficiaries, do a stretch out for your beneficiaries in light of the new 10-year limit. And then we'll also talk about the new coronavirus rules, which change when you have to take distributions and how you can take distributions. So the Secure Act stands for Setting Every Community Up for Retirement Enhancement. It was passed as part of another bill in late December of 2019, but it was effective on January 1st, 2020. So really wasn't a lot of time for people to get ready for this or to do any planning for it. And so that's what we're doing now, and hopefully this seminar will help you start to do that kind of planning. The Secure Act is effective on January 21, 2020, not only for IRA participants, but for IRA participants who die on or after that date. So the old rules still apply if you have participants who died in 2019. So you've got to keep both sets of rules in mind while we handle this. The other act that we're going to talk about is the CARES Act, which stands for Coronavirus Aid, Relief, and Economic Security. And the effective date of the IRA rules and the CARES Act are also January 1, 2020. So pretty much we are now in this new era. The main change that most of you have heard about is that the stretch out was eliminated for IRAs. Now, step back a little bit. The default rule is 5 years. If you don't qualify under some other section of the code, then an IRA has to be distributed completely within 5 years, either 1/5 every year or all of it in the last year. And typically you would do it in ratable portions just so you don't bunch income together. Again, that depends on how large the IRA is. So you have to pay it out in 5 years if the IRA is payable to an estate, to a charity, or to other non-qualified beneficiaries, which includes many trusts. And the trouble with the 5-year rule is it greatly accelerates income taxes because it bunches all this income not over someone's life expectancy, but in 5 years. Now, in the past, one way we could solve this 5-year rule problem was to name a spouse as a beneficiary. A surviving spouse has two options, or actually three options. They can continue taking the beneficiary as fast as the deceased participant was taking it. They also can roll over the IRA, treat it as the surviving spouse's own IRA, set up new beneficiaries, and then start taking out based on new beneficiary rules. And so naming a spouse is a very effective way to deal with it. And fortunately, under the current laws, that has not been changed. Also in the past, you could avoid the 5-year rule by naming a child as a beneficiary or another younger person. And some of our clients name grandchildren as beneficiaries because they were so young. And in those cases, that child or grandchild could take the IRA out over their life expectancy. Again, with a young person, for example, a 25-year-old has a 57.2-year life expectancy. So if they had inherited a $500,000 IRA, they could take out as little as $8,700 in the first year, pay tax on that small amount, and then keep doing that every year for the rest of their lives, and have it be growing tax-free that whole time. Now, a lot of times our clients are either in a second marriage, or they're concerned that the surviving spouse might remarry, or that the kids might get the IRA and then immediately just withdraw it all, or withdraw it all on things that they don't think would be appropriate. In other words, do bad income tax planning. And then also, sometimes you have a beneficiary who simply can't take care of money. And in those cases, the way we avoided the 5-year rule is to name a trust and then give the trust certain provisions which caused it to qualify as a see-through trust, which means the IRS would see through the trust to the underlying beneficiaries, and then the distribution rules would follow what would be the rules for that beneficiary. And so instead of 5 years, again, the beneficiary, if it's a spouse, could take it for the spouse's life expectancy. And if it was a child or grandchild, they could take the IRA out for their life expectancy. So we were able to get the same benefit, but hold the IRA funds separated from the beneficiary, so the beneficiary couldn't just take it out faster or use it improvidently or end up giving it to different beneficiaries than the participant wanted. And so, as an example, if you had a 50-year-old child who inherits a $500,000 IRA, they could take it out over their life expectancy, which would be about 29 years. Again, very different than the new 10-year rule. Now, the 10-year rule, unfortunately, is now the default rule, and we'll talk a little bit more about that as we go through this seminar. And just so I say, so instead of the 5-year rule and instead of the life expectancy rule, now we're looking at a 10-year rule, which says that the benefit must be distributed out within 10 years of the death of the participant. So again, not as bad as a 5-year rule. I guess it's twice as helpful. It's a 5-year rule, but still much quicker than the 29-year life expectancy of someone in their 50s, or even a 57-year life expectancy of someone in their 20s. And so again, this ability to grow the fund tax-free and then distribute it out in small parcels over time has been taken away. Now, I kind of alluded to this earlier when I talked about the spouse. There are 5 exceptions to this 10-year rule, and this slide here talks about that. First is a transfer to a spouse. And so all the thinking you used to have relating to a spouse still applies. You can name your spouse, and the spouse can take it out either over the life expectancy of the participant or roll it over, treat it as the spouse's own, and then take it out over that spouse's life expectancy. There is another exception, and that is transfer to someone within 10 years of the owner's age. And the thinking behind this is someone who, these exceptions are designed to blunt the impact of a 10-year rule. And the thinking here was, if someone's not married but has a significant other, for example, or wants to benefit a sibling who may be within their same age, that they're not stretching out the distribution because these beneficiaries are roughly the same age as the participant. So should the participant die early, this beneficiary, who's also a similar age, can take that same distribution. Another big exception is a transfer to a minor child. But note that it's only a minor child of the account owner. It can't be a grandchild. It can't be a niece or nephew. It can only be the account owner's child. And the 10-year exception is only delayed until the child reaches majority. And we'll be having to wait for some regulations or some more guidance on what majority is In most states, it's 18, and that includes Florida. Some states it's 21. And then there are some regulations under the Section 401 rules that extend minority to age 26. And if you remember, under the healthcare laws, people could get healthcare to age 26 under certain circumstances. Under the regulation here, what it says is if the child is continuing on some form of education, then they're allowed to be treated as a minor until they reach up to age 26. Another one of the exceptions is a disabled person, and then a chronically ill person. And Section 72 of the code defines disabled as someone who's not able to perform without assistance at least 2 activities of daily living. So this is a definition we've probably heard under disability laws and things like that, disability policies. And those activities of daily living are like bathing, dressing, feeding, transferring, toileting, and continence. So if someone can't do at least 2 of those activities, then they would be disabled under the statute, and we're waiting for regulations for how you prove that. Similarly, the definition of chronically ill is under Section 7702B of the code, and it's a 2-pronged definition, or it's 2 different scenarios. One is that you're not able to keep a job due to a physical or mental impairment that's likely to cause death or is of an illness of indefinite duration. So someone who's obviously seriously ill and not able to have a job. And the other is someone who requires substantial supervision to protect their health or safety because of a severe cognitive impairment. So these are helpful exemptions, but they don't really apply to the typical situation where our clients would say, we want to do the stretch out over our children's or our grandchildren's life expectancy because of the tax benefits, but also because these funds are protected from them if we run it through a trust, from them using the funds too early. Now, the other thing to take note of is if the trust is a mix of qualified and non-qualified beneficiaries, if you set this up through a trust rather than naming them outright, the 10-year rule applies to all the beneficiaries. And so we'll talk a little later about some drafting that trusts need to have to deal with situations where you've named people, some are qualified, some are non-qualified. And the other problem is of course your beneficiaries today may not be disabled or may not be chronically ill, but may in the future be disabled or chronically ill. And similarly, if you have children and they're young, the last thing you probably want is the 10-year rule to kick in during their 20s. So we'll talk some more about that as well. I want to talk just a little bit about some of the other changes that are under the Secure Act. And one of those is that the age when you have to start required minimum distributions has been raised from 70.5 to 72. So that adds about 1.5 years, 2 more years before you have to start taking the RMDs. So for clients who have IRAs that they don't need, this gives them a little more time for the fund to grow income tax free. Now, the Act also said that if you inherited an IRA in years 2015 to 2020 and the 5-year rule applied to it, that you're going to get a 1-year extension. So basically it's a 6-year rule. The other big change is that there's not an age limit now on making IRA contributions, even if you're already taking required minimum distributions. But the caveat is as long as you have earned income. So you have to have the earned income to support the IRA contribution. But even if you're 75 and you are earning income, you can continue making IRA contributions. So you continue adding to the IRA. The other change, well, and then one other one that's a very minor change is that the 10% early withdrawal penalty, if you're under 59.5, has been waived on the first $5,000 if you use it for birth or adoption of a child. And typically someone who is in the process of having a baby or adopting a child would be under age 59.5. If they used $5,000 of their IRA for that under the old rules, they'd have to pay a 10% penalty, and that penalty's been waived. So what do you do now, especially if your IRA is going through a trust? Because for most people, the reason they set up a trust was they didn't want the IRA to be in the hands freely of the beneficiary. They wanted to control the distributions. Even under the old rules, if an IRA was a trust, there were two ways you could have it be a trust and be treated as a see-through. One was the required minimum distributions had to come out and be paid to the beneficiary along the way. And so even with the old rules, if you named a trust, you couldn't just keep all the money in the trust. Some of the money had to come out, but at least it only came out at the required minimum and basically stretched out the IRA over the life expectancy of the beneficiary. The other way to do that was to have an accumulation trust, and they generally weren't favored by planners because in an accumulation trust, yes, you can keep the RMDs inside the trust, but you also pay the income tax on the trust, by the trust, not by the beneficiaries. A lot of times the beneficiaries are in a lower tax bracket, whereas a trust reaches the top 37% tax bracket between $13,000 and $19,000 of income. So a trust could very quickly end up in the 37% bracket, whereas beneficiaries, if it wasn't an accumulation trust, instead it was a see-through conduit trust, then there would be taxes saved. So a lot of times people would do the conduit trust. This is where the RMDs have to pass through. Basically, the trust is a conduit for the funds. But now the rule is going to be that it has to come out in 10 years, and that may or may not be what was intended, especially when the life expectancies of these beneficiaries are often decades longer than the 10-year rule. So first off, you always want to have someone who is trusted and who's knowledgeable about these types of plans, because it's very easy to make mistakes along the way. And so here are some options that you can consider. One, you could consider converting your IRA to a Roth IRA. That does not change the 10-year rule, but you're paying income tax now on a fund that may be lower in value due to the stock market being so low right now. And then when the beneficiaries get these accelerated funds in 10 years, they won't owe income tax because it's a Roth distribution rather than IRA distribution. So that's a way to leverage the tax rates, basically, and leverage the fact that the stock market's a little lower. So when you make this Roth conversion, it's not as expensive. And there's some other planning you can do. Instead of doing a Roth all in 1 year, if you are in a lower tax bracket, that you convert small portions over several years, staying clear of the top 37% bracket. The other option is you could make your IRA payable to a charitable remainder trust for the benefit of the same beneficiaries as would have been beneficiaries of the IRA trust. And so the concept is you take some funds, put them into a trust that's called a charitable remainder trust. For the lifetime of the beneficiaries, the trust pays out either a set amount or a set percentage. So either an annuity or a unitrust payment. And then at the death of the beneficiaries, the remainder goes to charity. And the way the IRS works these out, the math today has to work out that the charity would get 10%. So this type of example may be a way to keep funds in a trust paid out over the life expectancy of beneficiaries, no estate tax consequences, no income tax consequences. But there is a gift to charity at the end, and so you do need to be charitably inclined to make that work. The other thing you could do, I alluded to this earlier, is you could change your trust to an accumulation trust. And so instead of being required to pay out the RMDs or the required minimum distributions, the trust accumulates the RMDs. And then the trustee is the one who decides how much is going to be paid to the beneficiaries. The trade-off is the money is taxed at the trust's income tax rates, which reaches the 37% bracket very early. And so there's a high tax cost to be able to accumulate these funds. And even though that's the case, the 10-year rule still applies. So when the child, so you still have the 10-year rule. You're just able to control the distributions and not even have to pay out the R&Ds until the 10-year rule completely applies. So now, the biggest thing that people will be doing if they're beneficiaries of trust is changing how those distributions are made. And this slide shows a few things that then help, but understand these changes are only a little bit of a help. They're not going to solve all the problems. So for example, you could say that the trust is going to distribute the smallest amount permitted by law, which under the old law would have been required minimum distributions, but under the new law, if it's still in effect, would be 1/10 distributions. And there's different trains of thought about that. If you do the 1/10 distributions, the beneficiaries are likely not to get thrown up into a higher income tax bracket, or maybe less likely. But you're also distributing principal out, and so there's less fund to grow tax-free over the 10 years. So you literally have to do some math calculations and figure out what's the best way to approach that. The 1/10 distributions idea simply avoids a huge income tax hit if on a lump sum distribution in the 10th year. The other reason you put these language in trusts is to remind trustees, hey, there are some rules here that you need to be following, and you don't want to make a mistake and not distribute anything until, say, year 11. Because if you do that, there's a 50% penalty. And at some point, you can even totally disqualify the IRA for income tax purposes. So, if an IRA only had $100,000 and you failed to distribute it until year 11, you would end up only having $50,000 to give to your beneficiaries. So again, reminders in the trust document help the trustee make sure that the trustee gets advice on how to make those distributions. That also reminds the trustee to do the math to figure out what's going to be the best way. The other thing is the drafting can do a lot of other things, and it will make the trust more complicated. So for small IRAs, this kind of language won't help because it'd be so expensive to modify it. But you could provide that the trust is going to change. That there's a switch that you put in your trust to say it's a conduit trust today, but I want it to be an accumulation trust if one of the for example, if one of the beneficiaries is disabled or chronically ill at the time, or later becomes chronically ill or disabled, then you could switch the type of trust. And as long as that happens before the participant dies, that would work. The other thing is you can switch beneficiaries, give the power to switch beneficiaries so that you can make the trust qualify for one of the exceptions or the exemptions. And then also cause the trust to separate out into separate trusts, so that if today all 3 children are fine, but next year one of the children becomes disabled, the trust by its language says there's going to be 3 trusts, one of them for the disabled child, and so the disabled child will be able to take out over life expectancy. So you've saved the stretch out for 1/3 of the trust, and then the other 2 for the other 2 children, the other 2 trusts will go out to them over the 10-year rule. So there's some flexibility you can put in there to try to deal with the fact that you have qualified or disqualified beneficiaries. As I had mentioned earlier, if you have a mix in a trust of qualified and non-qualified beneficiaries, then the 10-year rule applies, even though some of those beneficiaries are an exception to the rule. The other thing to take into account is to think about do some other things, like, for example, maybe take a little extra distribution and buy some life insurance and use that to make up the fact that the 10-year rule is going to apply and cause your beneficiaries to receive less funds. So I want to switch now and just talk a little bit about some of the CARES Act, which will allow for, give you some flexibility this year because of the economic dislocation of the pandemic. So for example, traditional IRA and Roth IRA contributions for 2019, if you recall, you can make the contributions for a prior year up to the due date, the original due date, not an extended due date, of the tax return, which is typically April 15th. But this year, your 2019 contributions can be made as late as when you file your return or July 15th, 2020. And this is because the IRS has extended the filing deadline for tax returns to July 15, 2020. Again, this is not an extended deadline, it is the deadline for 2020. And so that gives people a little more time to decide if they're going to make their IRA contribution for 2019. The other thing to be careful about, though, if you do make an IRA contribution between April 15th and July 15th, is many of the IRA custodians will just assume it's your 2020 contribution because in their computer, you made it after April 15th. So you have to be very careful to make sure that they code it as a 2019 contribution. Under the Secure Act, RMDs were still required in 2020 for those who reached 70.5 in 2019. The CARES Act has changed that, and that RMD for 2019 can be waived. And so that may get people a little flexibility to not be taking distributions when the value of the IRA is low. If you've already taken your 2019 RMD, the CARES Act does not address or offer any repayment options. And perhaps the IRS will address this in the future. If you've not taken it, if you've taken it within the last 60 days, you may be able to get your custodian to take it back because if you recall, with an IRA, if you take a distribution and then put it back in within 60 days, it's not treated as having been distributed. And so that may be a way for you to address that if you've already taken your 2019 distribution. There's also, under the CARES Act, a special coronavirus distribution. And there will be, and this is for IRAs, if you've been affected by the coronavirus, and it's related to coronavirus-related expenses. So there's, it's not just you can take $100,000 out of your IRA because of coronavirus. You have to have been affected by the coronavirus, but there is some flexibility there. Not only diagnosed with it, but it could be a spouse or dependent or child, or you could have adverse financial consequences as a result of the virus. And so people who got forcibly quarantined or who weren't able to work because they were caring for their children who were out of school, or their hours reduced, or they got furloughed, those are adverse financial consequences. So if you're under 59.5, there's no 10% penalty if you withdraw the 100,000. It is still subject to income tax, but you can report that income over 3 years in 2020, 2021, 2022. And you can also return the funds, treat them like borrowed funds, if you put it back into the IRA within 3 years of receiving the funds. And so IRAs don't normally have loan provisions, but this is this is similar to a loan provision. Now we're still waiting on guidance on what a coronavirus-related expense is, or who would be affected individuals, because it's still a little vague in the statute. And then all the other IRA rules and distributions still apply, except as stated as above, which is the waiver of the 10% penalty and the fact that you can pull it out, put it back over 3 years, report the income over 3 years and put it back within 3 years and have it still be qualified in the IRA. There are some rules for 401ks. I'm not going to talk as much about that today. The prior rule was that 401k plans could have rules for taking loans. If they did have a rule for taking a loan, it was still capped at $50,000 or 50% of the value of the plan. The new CARES Act changes that to $100,000 or 100% of the plan. But otherwise, rules applicable to 401ks still apply. And then there's one little extra here. If you had taken one of these loans in a prior year and it was due to be repaid in 2020, then you also get a 1-year extension. You don't have to pay that until whenever the loan would have been due in 2020 plus 1 year. So that's another little bonus designed to help people not have to use cash right now in the pandemic. And I want to talk a little bit about some other pandemic-related planning options. And part of this is because the stock market has caused the value of assets to go down. And although some of our clients are in hunker down mode and just trying to figure out cash flow to keep their businesses going, other clients, particularly retired ones, are have sufficient funds, and these low values in the stock market are actually a good time to push assets out to other generations, avoiding estate tax. And given the pandemic and given the spending on the pandemic, most planners assumed that in 2026 the estate tax exemption would drop by half. Now, I think all bets are off whether the estate tax comes back or the exemption's lowered even more to help pay for all the government spending. So one example is annual exclusion gifts. If you have a stock that in theory is going to bounce back, and there is an assumption here to these planning options that the market will bounce back in the next year or so, but assuming it does, if you take an asset that's because of the stock market being down is lower in value by 30%, and say it's $10,000 asset, and now it's only worth $7,000, and you use that asset to gift the $15,000 per person per year to beneficiaries, and then the asset goes back up after the beneficiary gets it to its original $10,000 value, you've not only gotten the $15,000 you got out to the beneficiary, but you've also gotten out that extra 30% when the asset bounces back in value. And you don't necessarily have to make these gifts directly to a beneficiary. You could make them to an existing insurance trust that has crummy powers of withdrawal, or you could set up a new trust and fund the trust and do the same thing without giving the funds outright to the beneficiaries. Another option when interest rates are low, and right now the 120% AFR, which is one of the factors used to value remainder interest in estate planning interests, it's at 0.8 and expected to go lower. And just by way of example, in January, so just 4 months ago, the rate was 2.0%. So it's dropped by more than half in just 4 months and expected to go lower. So in a GRAT, you would again take, say, stock that is now lower in value, put it into the GRAT, take back a annuity payment over a set number of years, hoping that you outlive the term, and then at the end of the term, the balance goes to your beneficiaries or into a trust for your beneficiaries. So again, you're getting to leverage the gift by using stock assets that are lower in value. The same with the charitable remainder trust. We talked about doing that earlier as a way to stretch out the IRA distributions. Again, you're funding that charitable remainder trust with low value assets, and you're not even having to worry about the capital gains because the capital gains will go away inside the charitable remainder trust. And then last is, and you'd want to work with your CPAs to do these calculations, but if you're expecting your income to go up in future years, you may want to harvest some losses now and then plan to carry them forward in future years. So those are my prepared remarks. I think now if someone has questions, we can answer those.
Ladies and gentlemen, if you have any questions, if you could just type them into the questions section of the webinar interface. I don't have any questions, Tom. Or wait, we do. We have a question. Let me read it for you. Here we go. Okay, does the RMD waiver for 2020 apply to inherited IRAs?
It does not. It does not.
Okay, next question. If you took an RMD in 2018 but forgot in 2019, can you not take the 2019 RMD?
Well, the good news there is that the CARES Act says you can waive the 2019 RMD. If you're the IRA participant. So that's the main change. And I think I said it earlier, but the bad news in the change in the law was the 10-year rule, which, as I said, when you're giving these IRAs to grandchildren, they might have a 50 or 60-year life expectancy, and the growth of an IRA over that time would be substantial. For children, again, they might have a 20 or 30-year life expectancy, and again, when you run the numbers for a child in their 50s, a $1 million IRA could pay out $1.75 million over that child's life expectancy, and still have 750,000 in it. But with the 10-year rule, you lose about $750,000. So it's a significant hit when you have to take the distribution early. The good news is there are some exceptions. The biggest one for most of our clients is the spouse exception, because that's the main planning that we do with trusts is for typically a second spouse, or a participant who's worried about a spouse remarrying. In either situation, the spousal exception is a great benefit. After that, it's just not good news. So I wish you all good luck on sorting that out. We'll be working through this, making changes to our trusts in the coming year for sure.
I have another question here, Tom. For the coronavirus distribution, is there a new IRS form to reflect the 3 equal installments for 2020, 2021, and 2022?
I'd have to look and see. I don't know. I assume that they probably haven't put something together yet because we don't even have our 2020 returns, forms yet.
Next question here. Current law allows distributions to be made directly to the charity from an IRA. Has the new legislation expanded this? If so, how?
Well, what the new legislation did is it actually makes a carve out if you have earned income. And so it's actually not as helpful in that sense. And that is, if you had, say you had 10,000 of earned income and you made 10,000, you just did 100% $10,000 contribution to your IRA, and then you also gifted to charity $100,000, it would only be treated as a $90,000 contribution to charity. So that's the main change that happened under the act. But that's really just to adjust for the fact that you can make contributions after 72.
I don't have any more questions, Tom, so I'll let you give some closing remarks.
Okay. Well, as I was saying earlier, we definitely need to plan for the 10-year rule because it's going to surprise not only our clients, but it's going to surprise, it's going to be a surprise for their beneficiaries who may suddenly have income tax problems they weren't expecting. It also will thwart planning that was done for beneficiaries who can't handle money, but who may not be disabled or chronically ill, but just aren't good handling money. And so planning is going to have to be done for that outside the rules, because the 10-year rule for most beneficiaries is not long enough. So I thank you all for coming today. And if you have any other questions, feel free to email them to me and we'll make sure you get an answer.